rules apply. So here in Hudson, we would follow and we still do follow WIAA on any transgender students in sports.
And Tara, just so everybody's clear, you can find WIA's policy on transgender children participating in sports. It's a 2018 memo that they put out. It's a 2-page memo. It's on their website. That still is kind of carrying the day right now. And so if somebody wants to look that up, that is right now kind of the law of the athletic land in the state of Wisconsin. Because the new policy, the new Title IX guidance specifically says, we're going to give you more guidance on athletics. We're just not doing it in this first 1,500 pages. So that's a big piece.
Correct. Those are the only updates.
Okay, so we're reducing 2 separate policies, one for staff, one for students, and creating one that will combine them with the other 2 policies stay in effect because of the grandfather.
There's no statute of limitations on when somebody can make a complaint. So if someone comes back in October and says this happened in May of 2024, we have to refer to policy 413 and 513 still.
Mr. President. And so this policy has nothing to do with sports, is what you said.
Correct.
We're following WIA policy.
Correct.
So, question, because I'm ignorant. I'm not a fan of boys walking in girls' locker rooms. That said, hypothetical situation. So, starting middle linebacker, Monday gets out to practice, great practice. Tuesday comes in and says, I feel like I'm a woman today. With the policy, would that male student then transition, if you will? Would that middle linebacker have the right to walk into the girls' locker room?
No.
Okay, why is that?
The Title IX policy has nothing to do with sports. We would refer
WIA
to
policy.
WIA policy. There's a lot of pieces to that. Potentially, I guess potentially. If they meet all of the pieces on the WIA transgender policy, then yes, they could.
Okay, but it can't, just my example, you can't have the middle linebacker Monday decide they want to transition Tuesday and just walk into the girls.
Correct.
The other thing about this policy is I was going to say, not only will eventually replace both policies, but this policy not only does it not mention athletics, it also does not mention bathrooms, restrooms.
Or locker rooms, yep.
Yep. And so what this is doing is it's referring to Title IX. So if Congress decides to change the language of Title IX, we don't have to change our policy. That's up to Congress. It's not up to us to change Title IX. We can't do that. So, secondly, also, when it comes to interpreting what it means, because right now we've got, as was referenced, we've got half the states that have an injunction in place and the other half don't. And ultimately, it's going to end up in the Supreme Court. We don't have to play Supreme Court as to what Title IX means. What we're setting forward here is a grievance procedure to say, if you are discriminated, this is what happens, and how your case may be addressed. So it requires just an act of discrimination. Whether it's discrimination or not, that's determined by Congress in the language of Title IX and interpreted by the courts ultimately. And right now we have conflicting courts, I guess, in the Court of Appeals.
Yes, President.
Yes.
So, question for Nick and Tara. Is there any legal peril if we don't take action on this time?
No.
So, as I sent you guys an email from our attorney, so the injunction, as it relates to crisis states, it enjoins the Department of Ed from holding school districts accountable for implementation of the new rules. However, what you have to understand is the injunction is by a Kansas court, not our circuit. It enjoined for people that have children in school districts in other states that are members of 3 different organizations. We do have those students in our district, the parents of those students, in 4 of our 8 buildings, according to the most recent list. So that means in 4 of our buildings, the Department of Ed is enjoined from enforcing it. And in 4 of our buildings, they're not. And, you know, our legal counsel, as Sam said, you, right now, for at least the 4 buildings that aren't enjoined, this is the law of the land. Whether people agree with it, don't agree. In addition, so we already have the 7th Circuit of Appeals in the Kenosha case, Whitaker versus Kenosha, that was settled in 2017. That is our jurisdiction. It says we have to follow this discrimination definition. We don't have a choice. That is the law. And our attorneys have said, if you choose to not follow the law when you are told this is what you're supposed to do, that is willful negligence. You then would open yourself up to exposure from a liability standpoint. If somebody was to sue the district based on discrimination and we didn't have a procedure in place for how we're going to deal with discrimination. So they believe, as I forwarded on to you, the recommendation is your liability comes from not having a procedure in place to address this, especially for the 4 buildings that aren't part of the injunction. So it is a horrendous position to be in because you have courts saying lots of different things, and the Supreme Court is going to have to act on this. They have punted, according to our attorney, they've punted 4 times already, but they haven't chosen to act, and it creates issue. But the legal advice that we're getting from our legal counsel is put the procedural safeguards in place for investigation of new Title IX violations starting August 1st. And that's what this is. This is a procedural thing of how we would investigate Title IX complaints moving forward. That's their recommendation. And I've sent all that stuff to you as we're through it. I think Megan had something that I think Kate had something.
Mr. President, so from the injunction thing is crazy confusing. I've never, not that I know a lot about injunctions, but I've never seen anything like this. But from my understanding, this doesn't change all that much on the ground for our school district in terms of how, like, we already have harassment and bullying policy. Like, it's not okay to harass or bully anybody at our schools for any reason, right? Like, it's never okay. It doesn't matter if someone doesn't like your pants, right? Like, this doesn't change that. But if we don't approve this, we open ourselves up to possible legal liability, which then could make the school district have to pay if we lose a lawsuit that our insurer wouldn't cover, which would then fall back on our taxpayers to have to cover possibly.
Yeah, I mean, that is what we're being told by the city council. So it's what I forwarded on to you guys, Shane, last week. And the thing is about attorneys is everybody has an opinion, right? I mean, you know, different attorneys have different opinions on this. This is what our school attorney says. Went through another Title IX, Tara and I sat through another Title IX law thing last week up at CISA 11. It was the same recommendation from another law firm out of the Twin Cities. Went to the legal conference in July for WASDA. Same recommendations from a different attorney. In order to provide the district the most legal coverage, you would implement this set of procedures for investigating a Title IX complaint. That's what we're consistently being told. That gives you the most coverage. There's the chance that insurance company would say, you've been given the legal advice to do these things. You choose not to do these things, we may not indemnify you and cover your expenses associated with something that you're doing.
That's malarkey.
Any further questions?
Oh, I do. So I'm reading what Sheena sent us. So I just want to read it so everybody has this clear. it says, "We also do not believe that a school district that fails to meet the August 1st deadline has any real risk of losing its funding. Indeed, we are not aware of any cases of a school district losing their funding because it failed to timely adopt a mandatory policy, and we do not believe this to be the case here, especially those school districts, not schools, included in one of the lists submitted to the court." I mean, that's from our attorney.
Right.
It's right there.
We tabled this a couple weeks ago, so now I'm curious why we're coming back to it.
It's different.
Somerset.
I think it's two different things, Kate. Like, so,
No, it's not.
Yep, that was referring to having the policy in effect by August 1st. If you didn't have the policy in effect, there was discussion on can you lose funds. So I think,
No.
and I don't want to speak because I didn't see that email, but
We're going to have silence in the crowd, all right? And if you can't be quiet, then we're going to be asking you to leave, all right? This is a civil proceeding here. You had your opportunity for speaking. That was at the beginning of the meeting. That opportunity is done, all right? Go ahead.
so I believe that's what the August, by not having the policy in place by August 1st and why we've waited, partially waited, we've attended a lot of legal conferences and trainings to see what our best course of action was. So if I misspoke on that, maybe that's what you were going to say on the two.
well, I
different
think it's
pieces.
two different things. Like, you losing your federal funding, if the feds don't give you your funding, is different than you are at risk for a lawsuit if we haven't implemented the policy and there's a Title IX complaint, we're not using the procedure. Those are two different,
Yeah, I don't think we're at risk of losing federal funding. I mean, your next paragraph, after when you read it, was, however, we remain concerned about potential liability arising out of a complaint filed by an individual, a student/family, arising out of a Title IX complaint, which could involve a transgender or gender nonconforming, or more likely cisgender students who are victims of sexual harassment or sexual assault on the district's property and within the school district's programs. Given the new Title IX regulations primarily discuss how districts are required to process complaints of sexual harassment or assault, it is likely that a lawsuit challenging how the school district process the complaint will focus on the school district's failure to adopt the complaint procedures as part of the pursuit of damages. So what she's basically saying is the set of procedures, so it doesn't have to be transgender related. It could be anybody that files a Title IX complaint. They could argue that because we don't have the proper procedures in place, that we have failed to do our due diligence, and then that would put us with liability. That's the paragraph that is most concerning, is because it outlines, it's more of a procedural change for us than anything.
This is from my heart, but I don't think it is procedural. I feel like the Olympics, I never in a million years would have thought that I saw what I saw with men taking over women's sports. And I have daughters, and I absolutely will not ask them to take a back seat to having somebody change. And I know you're saying that's not in the policy, but there's a lot of things that I didn't think would happen that are happening.
Totally get it.
And this is something where I absolutely have to take a stand on. I can't believe some of this wording. I can't believe that our society is right here. I think to be transparent, we should talk about what is happening in the school now. So, I mean, it's a little scary, and I think a lot of us are there, Tara, so I'm not picking on you. But when we say, could they go in the locker room, couldn't they? And it's like, gosh, I don't know, potentially. And then I hear no, and then
Just
that's
to be
scary.
clear, and maybe I didn't answer or understand Rob's question, could they go into the locker room under our current practices? Yes. Playing sports on a different team? No.
I don't understand.
I think she means.
If a transgender student is going to use a locker room or a restroom of their gender, let's say Rob's example, can you share your example again so I can?
Middle linebacker, Monday, great practice, Tuesday decides they want to change genders.
So if that middle linebacker decides they are female the next day, they can, under current, the 2017 7th Circuit, they can use the restroom and the locker room of the gender that they identify with.
And that's not
That
a school
doesn't-
district policy.
Yeah.
That's that's the federal law. I mean, and what we put in our memo in 2023 was, we wouldn't allow that to happen until the parents of that student were involved in that discussion. So no, they couldn't just say, today I'm gonna do this. It was, well, wait a minute, we need to have a conversation with the parents before we go down that path. We are not going down that path. However, we don't have the ability. The Elkhorn School District, it was just, they tried to block that. And a federal judge, just in the last week, said, while this is on appeal, you have to allow transgender students to use the bathroom and locker rooms of where they identify while on appeal, because more than likely, you're going to lose your lawsuit, Elkhorn School District, because it's already been settled by a 3-judge panel in the 7th Circuit, which is the court that oversees the state of Wisconsin. It's not a school district policy, it's just the law we're required to follow. We don't have a choice. And our attorney's been in here to explain that in the past. Whether you agree or don't agree with it, I'm not saying, one way or the other, I'm just saying we don't have a choice. It is currently the law of the land, Mr. President.
Is it something we could have Shana be in an open meeting and discuss this with us?
Absolutely.
I think
Yeah.
the public needs to hear from our legal counsel. Once again, it's just not, they don't just handle our district, they handle many districts and deal with this often. And I think Jamie said it very well earlier, where we have to deal with what the law is, not what we want it to be. And that's kind of, that's where I am. I'm not a constitutional scholar or hobbyist, and so I'm,
You don't have to be.
That's why we pay the lawyers what we
Exactly.
Mr.
Mr.
President?
President, yeah. And so, I mean, a couple things. First off, WIA, whatever, I'm not a fan of somebody 24 hours later just having the ability to walk into a locker room. That said, the issue at hand is this Title IX procedural piece. Does this have anything at all to do with students having the ability to walk into a locker room, bathrooms? Does this give or add to the rights, if you will, of a transgender student to walk into basically a bathroom?
I would say in some states, this does.
Was it in Wisconsin?
In Wisconsin, this has no impact on that because in 2017, the 7th Circuit Court of Appeals already ruled on this. But there are states, 26 of them, as people talked about, that aren't in the 7th Circuit, that this would give, in those states, additional rights. That's just not the case here. That's why, for us, this is more procedural than anything. And, the downside, one of the downsides of this policy of the new Title IX interpretations is we have to now train every single staff member in Title IX every single year. I mean, we're talking about unfunded mandates. It's an hour-long training every year for every staff member in the district. There's not much, there's not much we can do about that. But as far as it relates to transgender, the transgender discussion has already been settled in the courts that govern the Hudson School District. That's not the case in Florida or Kansas or some of these other states. In those states, it's a much bigger change. It would be a much bigger change.
Mr. President, I just, I understand why you share that example, Rob, but I don't, that's not what happens. Like transgender kids aren't the starting linebacker and just decide it's going to be fun to be trans or like want to change sports. That it doesn't happen. And there's not a lot of trans students in our district. There's not a lot of trans students in general. It's a small minority. It is a minority of students that is more likely to suffer from violence, to suffer from suicide attempts, to suffer from depression. And I just, I don't want any family that might be watching this or some kid who may or may not be out to watch this meeting and think their school district doesn't want them to feel safe at school every day. Because I think we all in this room want every kid to go to our school and feel safe and not be bullied every day. Every kid needs an education. Every kid needs to be able to be ready to get a job, go to college, whatever their path is. So I think we want to be careful that whoever we're talking about, we all talk about it with kindness and putting kids first, all kids.
Megan, I would agree that all students should feel safe. All students should feel not bullied. They should come to school and feel that they're in a safe environment no matter where they are, which includes transgender kids. But I also look at my daughter, who's going to be a senior. And so from a rights perspective, how do we help those transgender students and not, the middle linebacker who one day feels it's funny to say that they are changing, but also balance that with the rights of my daughter, because she shouldn't feel awkward or that she should give up track because there's a transgender student in that locker room. And so how do you balance the rights of both students so they both feel safe, they both are encouraged to do the things they want to do, and they both develop as they want? So and I guess we don't have to answer that tonight, but I mean, the rights of both are important.
I go back to the policy here, looking at definitions, what it relates to. It relates to complaints. It defines complainants. It talks about parental status and expands the definition: biological, adopted, foster, step-parent, legal custodian, or guardian. It talks about parties. It talks about the term relevant. Nowhere in there is there a definition for the term, as it relates to athletics or bathrooms. So we're injecting into this something that this policy doesn't even deal with.
Mr. President,
So
why has this come up then?
Because Title IX was changed, certain things were expanded, whether you agree with that or not.
Which are?
Well, one of them is this pregnancy, the pregnancy and related conditions. It defines even that. So getting back to making a personal family and stuff, if my daughter were to be getting, in a situation where she was pregnant, I would want her to have the protections afforded by the law and afforded in the complaint procedures if she was sexually assaulted or discriminated against. But if we don't have a policy in place that does that, then they don't have it, and then we're exposing ourselves to liability. This is going to have way more application to things other than transgender than it will to transgender issues. Way more. There's been a lot of things with Title IX that I don't agree with, all right?
Like
over
what?
the
I
years.
mean, because
But-
the
Well,
way
that
that
it's
you're
been used
explaining
and
it.
it can be weaponized. It was weaponized back in the 70s when my school decided to cut a bunch of boys' sports because they said they needed to have the same number of sports for women as for men. Now, I think, though, on the whole of it, Title IX has been a good thing for women and has raised their ability to be an equal gender. And so that's why ultimately what all these mean about the athletics, that's the WIA's purview. It's not in this policy. With regard to bathroom use and all that other stuff, ultimately, Candace, as Nick pointed, is getting kicked down the road. We're not the Supreme Court, we're not Congress. All we're doing is following a policy that other districts have, that WASB recommends and what our attorneys recommend. So it's either follow the legal advice of the attorney, that it's not going to increase one iota any rights or increase any instances of people using bathrooms or being in sports that they're not supposed to. There's other rules that deal with it. That's not addressed in this. This is more procedural, not substantive. There's nothing in here that talks about substantive rights about using bathrooms
Mr.
or
President,
athletics.
I am looking at 63 pages of injunctions and litigation given to us by our attorney, and 14 pages that has, I can't even count how many Wisconsin schools are listed, hundreds. To me, it's frightening to pass a policy that has so much going on. Whether it's about this or anything else, I wouldn't pass it. So I would recommend to table this until we can talk to our attorney and to wait until all this litigation has passed, so we can actually see what the courts rule.
Is that a motion?
Yes.
Second.
Is there a motion to table? Is there any, and a second, is there any further discussion?
I would just like to ask, what is the concern with approving the first read and having attorney or legal discussion come in? And could we, just by approving this is not voting on it and enacting it. There's still a second read. There will be a time for legal counsel to speak to us directly. I think when you say that, why is this become such a big thing? I think that, like I said, it's a bigger thing in different states, but a lot of the things that a lot of people probably here are concerned about are already there. It's already the law, and we're already following it. Whether it's
I would
like it or
contend-
not.
I didn't vote on that in 2017, on this policy and procedure.
No, I understand. that.
So-
Yeah, I'm not trying to change your mind or
Yeah.
anything, as far as just, I think the idea of tabling it might, we could table it at the next reading, after we have more information.
I just wouldn't feel comfortable voting on something that I'm not understanding very well, and I feel like there's just too many variables that I don't understand enough about, and I would feel much better about making a motion to approve something like this if I had an opportunity to speak with Shayna. She came to our work session, and we were able to have a robust discussion about this, and we really understand, because clearly it's controversial, and so I think we need to have our heads around exactly what it means. And I feel like it's premature for me to be able to.
Would it be better if Shannon came during a regular board meeting where it's broadcast, or is that okay or not okay?
Yeah, you can, yeah, absolutely. I mean, you can have her come in and give her take on this and why her advice is what it is. And I don't see an issue with that. I mean, what I have to do is check there and find out which dates work for. I mean, I can't guarantee it's going to be the September regular meeting. It might work better for an August work session, might work better for a September work session. But I can, if the board would rather hear from her first, table it for right now and hear from her first, we can absolutely set that up. So,
I would support that.
Can I please speak up for a second?
No, you're not, may not, sir, all right? So go ahead.
I appreciate that one of the things Megan brought up is being compassionate and empathetic to all people. As I listen to what people are saying, I completely understand what you say about your daughter, Rob. And, that's a very, as we know, shower, locker room, all that, very vulnerable time. On the other hand, I understand what you're saying, Jamie, is that we're not the proper authority to take this complaint to. That this is a limited policy that we need, in effect, to protect ourselves. And yet, I also agree with Lynn. I feel like my head is spinning, like, what? What just happened? I think we just need a little more time to understand this and be educated, because none of us are legal scholars here.
Mr.
So did
President?
Kate make a motion on that first?
There was a motion at table, second by Lynn. Is there any further debate on the motion to table?
I'm concerned about making moves that go against legal advice and open our district up to possible lawsuits. I think it is a good idea to listen to your lawyers. We are not lawyers. None of us are going to read the 1,500 pages. None of us are going to fully understand the 1,500 pages. Like, I don't know what's in the school lunch regulations that we approve every year. I don't read those. Like, how long are they? I don't know. They're super long. There's all these federal laws and state laws that we are not really in a position to decide upon. And it's not, so we're not going to protect pregnant students and staff in this way. We're not going to have the proper procedures that we're supposed to put in place, because I think there is a lot of misinformation around this right now. And I think part of why it's a big deal in some states, Kate, is that student gender identity doesn't, or someone's gender identity wouldn't fall under a Title IX sexual harassment in some states right now. Now, I would hope that everybody on this board and in this room doesn't think anybody should ever be sexually harassed, no matter what. That is